You're watching The Legal Breakdown. Glenn, we've got a huge ruling today that can cause at least a few people to breathe a sigh of relief. Can you explain what just happened in Wisconsin?
Yeah, the Supreme Court of Wisconsin just struck down an abortion ban that had been on the Wisconsin law books since 1849, a 176-year-old abortion ban. Once Roe v. Wade was overturned by the Dobbs case and the issue was sent back to the states, there were folks in Wisconsin who said, hooray, that means this 176-year-old abortion ban is revived. It's good law again in Wisconsin, and we can stop everybody from having abortions, or we can criminalize anybody who does try to have an abortion. And there was actually some force to that argument. Why? Well, because in the Dobbs case, the Supreme Court, that radical right-wing bloc of the Supreme Court, basically did away with constitutional protections. They did away with federal protections for women to make their own reproductive health decisions, and they said, turn it back to the states. Well, that old law had been on the books in Wisconsin long before Roe v. Wade ever created those federal constitutional protections. That was 1973. So people said, oh, great, then we go back to the old law. And there was a legal argument that that might be, the case. But here's what happened. The governor of Wisconsin authorized the attorney general to bring a lawsuit challenging that position. Specifically, what they said was, wait a minute. There have been decades and decades and decades of the Wisconsin legislature passing laws in the abortion arena, ever since Roe v. Wade came into existence. And all of those laws in aggregate now control and set the legal standard in Wisconsin. And basically that old law from 1849 is what's called superseding. It is de facto overruled by all of the other state laws that had passed in Wisconsin. And fortunately, albeit in a 4-3 split, there were 3 dissenters, the women of Wisconsin will again have the lawful ability to make their own reproductive health decisions. Let me just quote one sentence from the majority opinion, which was authored by Wisconsin Supreme Court Justice Rebecca Dollett. Here's what she said. She said, this case is about giving effect to 50 years worth of laws passed by the legislature of Wisconsin about virtually every aspect of abortion, including where, when, and how healthcare providers may lawfully perform abortions. But then she went on to note, look, the legislature, the Wisconsin legislature, as the people's representatives, remain free to change the laws with respect to abortion in the future. However, that 50 years worth of Wisconsin state law basically put a nail in the coffin of that old 1849 law, even though the Dobbs case did away with the federal constitutional protection of women's reproductive rights.
Okay, so to that point then, because we have this ruling handed down by the Wisconsin Supreme Court, is abortion permanently protected, as at least as of right now, until we see another law passed by the legislature, but permanently protected without any other recourse in the state?
Yeah, permanently is a tricky word, and I know you threw a caveat in there. There are
Right.
2 things that concern me on the permanence front. One is what the Supreme Court Justice, whose quote I just read, made clear. Listen, now that these matters have been turned back to the states, the Wisconsin people have voted, and the legislature has put laws in place, signed into law by the governor of Wisconsin, that protect women's reproductive rights, at least until the point of viability. And, then there are some Wisconsin laws that restrict what can and can't be done. So that is only as permanent as the people of Wisconsin decide, whether to, again, start kicking around an effort to cut back on
Right.
women's reproductive rights. But here's the other permanence question, and I'm probably going to jump the narrative here because I'm betting this was the next question. Could the United States Supreme Court grab hold of this case? Could they jump from the state system to the federal system, as happens sometimes, and, again, interfere now in the state of Wisconsin's determination regarding how to deal with abortion.
Well, to that point, I mean, I am going to pose that question to you, but I would presume that the Dobbs decision did not make a determination one way or the other on the merits of the legality of abortion. It just said that this is no longer an issue that the federal government is going to be able to adjudicate. This is an issue for the states. And so I would presume that if they tried to jump this case from the state court system into the federal court system, the precedent in the Supreme Court is just that, no, it doesn't belong here. It belongs back in the states. And so therefore we can't rule on this, and the Wisconsin Supreme Court's decision has to stand.
I'm with you on that interpretation. I'll bet at least 3 Supreme Court justices, U.S. Supreme Court justices, would be with you on that interpretation. And it is clearly the better argument that, listen, you know, you reap what you sow, Supreme Court. If you're turning it back to the states, then who gets to make the decision? The states, as you promised when you did away with the federal constitutional protections that women had enjoyed for 50 years. But here's the thing, Brian. Do you think if the 6-justice majority on the Supreme Court wanted to find some way to grant review of what the Wisconsin Supreme Court just did, which is basically cement, at least for the time being, a woman's right to make her own decisions, you don't think they would find some way to grant review and maybe even say, well, we turned it back to the states, but we're not sure the Wisconsin Supreme Court really interpreted what we said in Dobbs accurately? Now, that I think is a losing argument, but you know, I have been fooled before by the Supreme Court when they seem to rule against not only their prior rulings, but the express language of the Constitution.
Right, and so that I'm gonna pose a question here that I know a lot of people have, and that is, a lot of these Supreme Court justices during their confirmation hearing said that they were going to respect precedent, said they were going to respect stare decisis, said that as it relates to Roe, for example, that this was precedent upon precedent upon precedent. I believe those were Brett Kavanaugh's words. And so only for us to then watch them once they got confirmed and had the opportunity to rule on this case to go back on their word. And so I know a lot of people are watching this and saying, these guys clearly lied during their confirmation hearings. They were under oath during their confirmation hearings. How does nothing happen when it seems to us like they've committed perjury? And so I would pose that question to you, is you have these people acting in a way that is wholly antithetical to their own comments when they were under oath during their own confirmation hearings. And so how do you square that circle?
Yeah, this is perhaps the easiest question you've asked me in some time, because the answer is we don't have an appetite to hold the ruling class criminals accountable for their crimes.
Yeah.
Plain and simple. We see it in the criminal law arena every day where some, underprivileged kid sells a rock of crack. We jump on him with both feet. But some, CEO of big oil, big pharma, big tech, the military industrial complex, is caught red-handed, violating all kinds of federal laws and victimizing large swaths of the American people. What we do to that person is we give them a non-prosecution agreement, which seems like the exact opposite of what they should be subjected to. They're allowed to pay fines and penalties and back taxes and, promise never to do it again. And what do? They just factor those fines and penalties and back taxes into their operating budget, often passing those expenses on to us, the consumers.
Cost of doing business.
And they do it again, and they do it again, and they do it again, and they keep getting non-prosecution agreements. So even though I agree with you 1,000%, when in fact 1,001%, because that's the federal statute that somebody violates when they lie before Congress, 18 United States Code 1001. And these judges, in their determination to be confirmed to the Supreme Court, misled not only the Senate, but the American people, because as you pointed out, they said things like, whoa, Roe v. Wade, that's settled precedent. It's been affirmed several times over. Stare decisis, a fancy term for the thing has been decided, laid to rest. It's a dead issue. And that precedent of Roe v. Wade has nothing to worry about from me if I'm confirmed. And then what did Justice Sammy the Bull Alito write in his opinion killing Roe v. Wade? He said, Roe v. Wade was egregiously wrong from the moment the Supreme Court handed down that ruling. So thank you, Justice Alito, for putting the lie to your own confirmation testimony and that of your, radical right justice colleagues.
And finally, Glenn, let's finish off with this. After this ruling was handed down, what was the reaction that we saw from leaders in the state?
Yeah, it's a great question, Brian, because look, the governor of Wisconsin made it pretty clear where he stood on this fight. And it's a fight that he undertook years ago that has just come to fruition with the Supreme Court ruling. It's Governor Tony Evers who authorized his Attorney General, Josh Kaul, to file a lawsuit challenging the viability of this, 1849 abortion ban. And here is what he said. He said that the Dobbs decision upended 5 decades of precedent and threw reproductive freedom in Wisconsin and across the country into chaos. I promised then to fight like hell to ensure every Wisconsinite has the freedom to consult their family, their faith, and their doctor and make the reproductive health care decision that is right for them, and I've never stopped. Today, the Wisconsin Supreme Court upheld that basic freedom. I mean, how can you argue with, a political machine that says, listen, we believe that a woman, together with her doctor, her family, and her faith, in case people want to say you're really boxing out religion. No, you're expressly including religion, and you're letting the woman decide how her, religious beliefs, among other beliefs, will be her guide, not the 6 Supreme Court justices on high, making that decision for women against their will and over their objection. So I was inspired by the governor's take on this, and I was inspired by his fight and the fight of his attorney general in just trying to make sure that the women of Wisconsin, the people of Wisconsin, are protected.
Perfectly put. Well, we will, of course, stay on top of this if we have any updates. But hopefully, to your point, we have this settled law thanks to the Wisconsin Supreme Court that has struck down this longstanding 1849 abortion ban. And hopefully, this is a kick in the ass for other states to do the same, to do what they can to protect reproductive rights. So we will stay on top of this issue if there are any updates. For those who are watching, if you'd like to follow along or support our work, the best way to do that is to subscribe to our channels. I'll put the links right here on the screen and also in the post description of this video. It doesn't cost anything to subscribe, but it's the best way to support our work and independent media more broadly. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.